A divorce lawyer sends a letter to his client's spouse, threatening to reveal embarrassing information about the spouse's criminal activity unless the spouse agrees to a quick settlement. Is the lawyer zealously representing his client, or has he committed blackmail? This was the question in State v. Harrington. Norma Morin hired Vermont attorney John Harrington to help her divorce her philandering husband, Armand. Norma didn't have money to pay Harrington, so he accepted her case on a contingent-fee basis. The Morins owned and operated a motel in New Hampshire, and Armand lived in the motel. With the help of a private detective, Harrington organized an amateur sting operation to catch Armand in the act of adultery. Harrington hired a woman to entice Armand to have sex with her in one of his motel rooms. The woman succeeded, and while the pair were in bed together, Harrington and two of his associates entered the room and took photos of them. Harrington then wrote a letter to Armand, enclosing one of the incriminating photos. The letter informed Armand that Harrington had enough evidence to prove beyond a reasonable doubt that Armand had committed adultery, which at the time was a crime in New Hampshire. The letter threatened to publicly expose Armand's adultery in New Hampshire divorce court unless Armand agreed to pay Norma a lump sum divorce settlement of $175,000. Harrington was tried for blackmail in Vermont state court. Vermont's blackmail statute made it a crime to maliciously threaten to accuse another person of a crime with the intent to extort money. Harrington argued that he hadn't committed blackmail because, instead of accusing Armand of the crime of adultery, his letter had merely threatened to bring an embarrassing, reputation-damaging divorce action against him. Harrington was convicted of blackmail and appealed to the Vermont Supreme Court.